Okay, good morning. We're on? Okay. My name is Alec Ferretti, and we're here to discuss women and children's citizenship. We have a lot of content today, and I hope we'll get through it all, but we'll see how it goes. So, for those who are familiar with naturalization records, you often might think of a single document that is a couple of pages long. You have your declaration of intention where someone says, I want to become a citizen. You have the petition where they then later say, yes, we're going to become a citizen. And people often look at only those records. And these are often really thorough records, especially in later years. They record biographical information such as the immigrant's name, date of birth, place of birth, spouse's name, spouse's dates of birth, places of birth, children's names, arrival information, original names if they've changed it. They're incredibly detailed. But these are just one tip of the iceberg of records of citizenship. And that's really what we're here to look at today, the everything else that exists. And to do that, we really have to go back to the beginning of this country. In 1906, there was a bit of a watershed moment in citizenship law because the records became standardized at the federal level. And before 1906, everything was vastly different. And to be perfectly honest, before 1906, there aren't that many records, and they're not that exciting, especially for women and children. So if you are here to learn about the records of women and children who became citizens in the 17 or 1800s, there's not a lot to discuss. This talk is very focused on the 20th century, although we will be doing an overview of everything. In fact, we're going there right now. So starting in 1790 through the 1840s, Congress passed a bunch of laws that set various rules for how naturalization would happen. And for those who don't know, naturalization is the process of becoming a citizen. The initial laws limited naturalization to free white persons, and generally women and children could not naturalize. For a large part of the early part of US history, women weren't even contemplated in citizenship legislation. The men would naturalize, the women really did not engage in civic life. And it wasn't even so much that women couldn't become citizens, it was just more that it was not even a concept in discourse about citizenship and women. But that said, as time went on, the citizenship status of women and children did eventually get legislated and clarified, and lots of records do eventually exist. Now, two of the main things that dictated citizenship laws in the 19th century, and the 20th for that matter, were really about residency and paperwork. So there were different residency requirements in order to naturalize. Often it was something like you'd have to live there for 2 years or 5 years. And it instituted a two-step filing process, what I was saying before. The immigrant would first have to declare their intention to naturalize. They'd file a declaration. Some immigrants did it the day they arrived in New York. Some waited 15, 20, 30, 50 years. And then after a bit of a waiting period, they'd have to file the petition for naturalization. And this was all a court process. So they'd go to court and file these documents. And a judge would either approve or deny the petition. It's generally approved. Denial rates were relatively low, but they did happen. And if they were approved, they'd become a citizen. And this is an excerpt from the first law from 1790. It was enacted by the Senate and the House of Representatives that any alien being a free white person who shall have resided within the limits and under the jurisdiction of the U.S. for the term of 2 years may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term. And this is a law that was only from 1790. There were many different laws. I am giving a talk at GRIP this summer about the laws of naturalization that will cover more of this granularly. But for now, we're going to move on. The forms during the 19th century were relatively bare bones. And again, they really would only have men on them for the most part. The document would pretty much give the immigrant's name, their place of origin, perhaps an age. So here's some examples from random courts. The forms were not standardized. So if you're lucky, it's possible that some random court in Missouri decided to have a whole 10-page questionnaire. I'm sure if I were to search every single court, I'd find something like that. But in the 19th century, that is exceedingly uncommon. And you're almost exclusively going to find something like this. So we have various territorial courts from Idaho on the left, on the right, both are Idaho. And it records, the origin, Kingdom of Norway, Ireland, the name. There's really not a lot there. Sometimes they'll be handwritten. This is also from Idaho, and we get that the person, Joseph, is formerly of England, but the information on this is going to be very nominal. We can infer information based on the laws at the time. So if we know there's a 2-year residency requirement, then we can say, well, this person must have lived here for at least 2 years. But what we're really clutching at straws to learn information about these people. And the women, again, are not going to be covered. Here we have other examples. This is from California. Again, it mentions they're from Switzerland, again from Ireland. Here we have another one from California. We get a little bit more information. It records not only their place of origin, but it says their arrival date, October in 1898. There's some information, but they're really going to be rather vague. This is one from Massachusetts, and it gives a date of birth. He was born on the 27th day of October in the year 1805. It's going to depend on the court, and it's entirely up to essentially luck what a naturalization record from this era might say. Here we have a guy born in Bavaria. It says that he embarked at Le Havre in France in April 1834. It really just depends, and I don't want to go into this for too long. You get the idea. Every record will have different information. But again, they're almost exclusively going to be about men, and we're here to look at women. So there are some key dates about women's citizenship. We'll focus on these 3 for now. So in 1790, there was that initial law that I mentioned that limited naturalization to free white persons, which was generally understood to not really include women. In 1804, Congress passed a new law that specifically allowed the widow and children of a deceased declarant to appear in court and take the oath. In other words, if a male immigrant had filed that first step, the declaration of intention, and then died before he finished the petition, the widow could appear in court citing the initial declaration from the husband and finish the process on her own to grant herself and her children citizenship. Now, we have birthright citizenship in the United States, so the children who were born in America would have been born citizens. But if there were any children born abroad, they would not be until a proper naturalization occurred. Now, starting in 1855, we finally have some legislation that covers women's citizenship specifically. And this allowed racially eligible alien women to derive U.S. citizenship by marriage to a U.S. citizen husband. So if their husband is or becomes a citizen, the wife will derive citizenship. And racially eligible is a key phrase here because different races were not allowed to naturalize until certain times in history. If you were Black, generally not until after the Civil War, and many Asians were not allowed to naturalize until the mid-1900s. So really, we're looking at exclusively European individuals who would be deriving citizenship from their husband in the 1850s. So here's some examples of records. We do find women in the naturalization records. Here we have Marianne Kafka, who naturalized in a court in New York City. And despite it having her name on it, it's going to look pretty much identical to these other records I've been showing you. We get a name, maybe an age, a place of origin, but it's not going to tell us a ton of information. Here we have another one from a New York City court. We have Anna. She's a woman, so it's a woman naturalizing. We get her occupation, that she's a dressmaker. We get a year it's happening. Of course, all these records are dated, so we can tell when these things are occurring. There'll be addresses and names of witnesses, but it's largely just a bare bones court record saying that this person exists and some basic identifying information. We still are not seeing really detailed records. But the record will show the person actually naturalizing. So Anna LaCorde was ordered by the court to be admitted as a citizen in 1898. And as time goes on, we see more and more women appearing in the court records because women are getting more involved in civic life. They often can't vote, although some states did allow women to vote in local elections earlier than the federal government did in 1920 or so. But again, because women largely aren't participating in a lot of civic society, they are just not going to be interested in gaining citizenship as frequently as men would be. When we hit the 20th century, we finally get some fun stuff going on. Because again, until 1906, we're really just looking at court records. Court record of the husband, where we can infer the wife or children are naturalizing or deriving, perhaps a court record for the wife themselves in certain periods of time. But when we hit 1906, we get much more exciting documentation. And even people that immigrated decades beforehand might have this interesting documentation if they're not naturalizing until this time period. So the Act of June 29th, 1906 is one of the most important records in the history of naturalization laws, because that is the point at which naturalization became regulated by the federal government in a way that it had not been before. The forms were all standardized and they were expanded upon. And a duplicate copy of the record was sent to the federal government. So not only was there a court record on file with the given court, of which there are thousands across the US, but a copy was sent to the Bureau of Immigration and the Bureau of Naturalization and put in what was called a C file, a naturalization certificate file. And this is a standardized series where every single person who naturalized between June 29th, 1906 and 1956 had their records put in a file. And the information contained in the C file and the court record is largely duplicative for most of that time span. When we get towards the 40s and 50s, not so much. But it's a duplicate set. Now, shortly after that, in 1907, Congress passed an interesting and controversial law that did not age well. But in 1907, it was decreed by Congress that women would acquire their husband's nationality upon marriage to their husband as of that date, which means if I were a woman and I married an Irishman, I, according to US law, would become Irish. Now, the problem here is that the Congress cannot bestow a foreign country citizenship on somebody. So just because we, the US, considered this woman to be Irish, didn't actually make her Irish. Now, in some countries, marriage to a male of that citizenship might actually bestow the citizenship to the wife, but it just depends on the country. So this created a lot of chaos because it applied even to US-born women. The idea was simple, that a married couple should share citizenship, which in theory is not particularly crazy. But in practice, this completely falls apart because you could have a native-born US woman marry an Italian immigrant who's not yet naturalized, and this woman is now an alien in the country in which she was actually born. She's never left the US. She couldn't even find Italy on a map, but now, according to the US government, she is an Italian citizen. Now, luckily, Italy actually would consider her an Italian citizen, so she wasn't stateless, but she could have been. And this applied to alien women too. So if you immigrated from, let's say, Italy and married a US citizen, you would automatically become a US citizen. So it did go in both ways. And then if your alien husband eventually naturalized, you would derive citizenship from the husband, just as any alien woman would as of 1855. There were some other laws that covered in this time period. In 1911, Congress allowed the wife and minor children of an insane declarant who filed a homestead entry to petition for naturalization on their own. But largely besides that, during this time period, married women literally could not naturalize. So you could be US born, married to an alien, and to the extent your husband didn't or couldn't naturalize, barring this 1911 exception, there was literally no way to become a US citizen unless your husband became one himself. Now, in 1922, we stopped this because this is crazy. So as of September 22, 1922, Congress passed the Cable Act, and that ended the entire process of derivation for women. So women were no longer assumed to take their husband's citizenship status, and women no longer derive citizenship from their husband. So US born women were always going to be US citizens regardless of who they married. And more importantly, for more people, an alien woman who married somebody after September 22nd, 1922 would not derive US citizenship. And a lot of people fall into this trap because for so long, when a husband naturalized, the wife became a citizen. Now she no longer does. And many people whose husbands naturalized in the mid to late 1920s just assumed they were citizens because their husband was, but that's not how the law worked any longer. Okay, so let's look at some records. So this is one of those pre-1906 naturalizations. It's pretty similar to what I showed you before. We have Giuseppe Vicino. Again, not a lot of information. And this is actually just before the law changed. And this is a certificate that was signed in January 1906. So as of January 1906, it was still the Wild West, that every court did whatever they wanted. But come the rest of 1906, we have standardized forms. So here we have an example of my uncle, Sam Goldstein. He naturalized in 1911 with one of these standardized forms that we see on the left. And the form changed throughout time, but this is the top of what the form looked like in that era. And we see he's not married at the time of his 1911 naturalization. The following year, he married his wife, Gussie, in 1912. They were both Austrian born. So because they were married in 1912, from the moment of this marriage, his wife, Gussie, became a U.S. citizen. The record of her citizenship is essentially that marriage certificate. The marriage certificate with the naturalization petition for her husband would be the documentation that one would expect to find in most cases of a woman who derives citizenship. And of course, neither of these records say that, but when you know the laws and look at the records, we can interpret what happened operatively. Now, we do find some records that somewhat document this. In the 50s, Sam and Gussie went to Israel and they got a passport. So I got their passport from the State Department, and it documents all this information. It records when and where Sam naturalized. It records when and where they got married. And of course, to get a passport, you have to be a US citizen. I think there's actually some exceptions to that. But in the 20th century, you have to be a US citizen. I believe we did issue passports to alien permanent residents at some point 100 years ago, but neither here nor there. So Gussie and Sam are both U.S. citizens traveling on a U.S. passport, and it's because Gussie derived citizenship in 1912 when they got married. Now, we do find some women naturalizing again in these more thorough post-1906 records. So again, married women in 1907 to 22 literally cannot naturalize on their own. It is actually prohibited by statute. But in this time period, we do see single women. So we have Breda O'Leary, and they've even noted that she's single, likely because if she were not single, it would be attracting scrutiny because she otherwise could not get married. And she files the same forms as a man would file, at least that are in use at that particular time. So we have the Declaration of Intention on the left, the Petition for Naturalization on the right, and I have cropped that. It's a longer form. There's a bit more information, but those are the highlights. And she becomes a U.S. citizen in 1916. Here we have Mother Cabrini. She was a nun. This may come as a surprise, but that means she was not married. So Mother Cabrini could naturalize. And she naturalized in 1909. And she actually filed her Declaration of Intention before the law changed in 1903. So as one little aside, until the 1906 law, declarations of intention did not expire. So if you filed your declaration in 1895, you could then file the petition in 1904 and it would still be valid. Once the new 1906 laws started, Congress had an expiration date of 7 years. And you could no longer use the declaration after 7 years. You'd have to file a new one. So often you'll find an immigrant that might have declared 4 times over the course of 40 years and never become a citizen, but each time the declaration expired. Eventually, there was a court case that decided that the pre-1906 declarations that didn't expire actually did expire. But for a while, you could use those pre-1906 declarations for years and years and years. And that's what Mother Cabrini did. She declared 1903 and then naturalized under the standardized forms in 1909, which actually would have been in the 7-year window. But even if it weren't, it would have still been allowed at that time. The court case was in 1915 or something like that. And as we see, these records have tons of information on them. It records the immigrant's name, date of birth, place of birth, their arrival information, the ship on which they arrived, the date on which they arrived, if they're married, their husband's name, their spouse's date of birth, place of birth, children's names, children's places of birth. These post-1906 records are some of the most thorough and detailed documents you will ever find about a person in this time period. Now, the idea of naturalizing on a husband's declaration didn't go away. That was still allowed. So here we have Maria Marzillo, who naturalizes in 1927. Now, this is after the Cable Act, so she could naturalize on her own, as could any woman at this point, and she would not derive from her husband naturalizing. But she'd still be bound by the two-step requirement of filing a declaration and then the petition, except she did not file a declaration. She filed her husband's. So Giuseppe Marzillo, her husband, filed a declaration in 1921. She naturalized in 1927, citing her husband's declaration, because in the interceding years, he died. So because she was a widow, she was able to use his unexpired declaration to skip the requirement of filing her own declaration. And she did that. Here we have an example that is citing one of these declarations I was discussing before. We have Rudolph, who declared in 1875, and then his widow finally used that declaration to naturalize and file a petition in 1914. So this was 40 years later. He'd croaked at some point in the interceding years, and she was able to use his declaration. And again, around this time period, the court said that was not okay, but it was still okay in this era. Okay, now here we have a fun petition. We have Cleo Beatrice Basso, who's naturalizing in 1935. Where did she immigrate from, you might ask? Well, she was born in Zanesville, Ohio. So she immigrated from Zanesville, Ohio. And this is because she married an alien during the 1907 to 1922 range, where native-born women who married aliens lost their citizenship. So she had to naturalize in the country that she was born in, which is a very demoralizing process. And if you read the petition, it'll often specify things like this. So it says she was born in 1905, she declared her intention to become a citizen, and it has omitted under the Act of 922-22. And that's because the Cable Act, which is that act, allowed women to skip the declaration of retention requirement, essentially as an apology from Congress for doing such a terrible law. They at least made it easier to naturalize in the country of your birth, and it skipped one of the forms. But she still had to naturalize, which she did in 1935. Now, sure enough, she and her husband, she married her husband in 1922. She missed the date of the Cable Act by a very small margin, but still married before the Cable Act to an Italian man, which meant she lost her U.S. citizenship. Now, her husband never naturalized. He filed a declaration and thought he did and often claimed to be a citizen, but he never actually was a citizen. So she, on her own, renaturalized. And if we look in her P file, which is a record that USCIS has locked away in a warehouse in Missouri, it's the petition file, the records of the naturalization examiner, there's more information discussing this. And there's a whole conversation about trying to find her birth certificate. And I love the line about her absences from the U.S. And she says, never been out of the United States. This woman who's never left the country is naturalizing as a U.S. citizen. Okay, we got to move on. We got a lot of content here. So starting in 1929, women who derived U.S. citizenship through a husband's naturalization after marriage could apply for a certificate of citizenship. So before I mentioned my Uncle Sam and Gussie, and I was saying that Gussie doesn't have a record of her citizenship besides the marriage license and the husband's naturalization record. In her case, that's what it is, and that's how it is for most women. But it's not necessarily the case for everybody, because as of 1929, women who derived, who wanted a more substantive proof of citizenship, could request a certificate of citizenship from the Bureau of Naturalization. And they would have one of those C files. So earlier I mentioned how starting in 1906, there was a duplicate copy of every court naturalization sent to the feds, and that was put in a C file. But C files weren't just the court naturalizations. There were about 10 different kinds of C files. I give talks on that, not today. But one of the kinds of C files is a derivative A certificates file. And those were what were given to people who derived citizenship from generally a spouse or a father. Um, and that way, they would actually be able to hold a document that says, yes, I am a citizen. It would have a picture of them on it. It would be a very clear record. And on top of the certificate, there'd be a whole pile of documentation. So, in theory, any woman who derived citizenship from their husband, who lived until 29, could have applied for one of these derivative certificate files. And if they did, there would be a 10, 20, 50, 100-page case file with the federal government at USCIS documenting the entire life of the immigrant. Now, the reality is most women did not bother to do this. There are hundreds of thousands, or at least tens of thousands, of derivative files. Many are male children of naturalized fathers, but an unknown number are also wives of naturalized husbands. And USCIS has these records. Um, Moving on, in 1936, we passed a new law that made the process for women who lost their citizenship by marriage even easier. So notice that Cleo naturalized in 35. If she'd waited one more year, she could have avoided naturalization and could have repatriated, which was an even more streamlined court process where essentially the alien, for lack of a better word, will go to court and take an oath. And then it would be a one-page form. They'd say, I'm going to become a citizen again. And they were kind of waved through. And this led to another kind of C file, the 129 files. And these are all the repatriation records. So the court would have a repatriation one-page file on hand. USCIS would have a fuller file documenting the citizenship. And then in 1940, with the Nationality Act, they expanded how certificates of citizenship would work. So all women who lost citizenship by marriage could resume or repatriate by taking the oath. As of 36, I forgot to say, it was only the women who lost their citizenship if the marriage was terminated. Whereas if they were still married to the alien husband, they had to wait till 1940. But regardless, the records would be in these C files with USCIS and potentially a one-page form with the court if they were repatriating. So here we have an example of what one of these certificates of citizenship looks like. This is from Amelia Motrani. She derived citizenship upon marriage to her husband. I actually found this woman because her original certificate is on file at the Ellis Island Museum in actual Ellis Island. And I saw the certificate there, and I thought it'd be cool to research her a little bit. So I was able to get a copy of the file with the government, and I now have this in my talk. And there'd be a whole case file on top of this that would have records of her having derived citizenship. Here we have an example of the Oath of Allegiance. We have two people who repatriated in district court in New Jersey. So we have this one-page form which gives some biographical information, name, date of birth. It looks similar to a naturalization petition for sure, not as detailed. And then there is a corresponding repatriation C file with USCIS. And at the same time, women are often just naturalizing on their own. Once you get to that post-1922 era where naturalization is severed between spouses, women could just naturalize. So we have my fifth cousin or something, Irene, who immigrated here from Austria right before the war and filed a declaration of intention, filed a petition for naturalization, and became a citizen like any man would have as well. By this time period, I don't know any numbers offhand, but women naturalize all the time. It's probably still less likely than a man naturalizing, but by the mid 20th century, women naturalization is a very common occurrence. And she and her husband naturalized pretty much simultaneously. Now, this is all records of citizenship, but what about records of aliens? And I have many USCIS records themed talks. Again, that is not what we're here for today, so I have to gloss over this in a much more general sense. But let's look at my great-great-grandfather, Peter. So Peter Varela was born in Italy. He immigrated in the 1890s, naturalized in 1924. So because he naturalized after the Cable Act, he became a U.S. citizen. But his wife, Maria Arcangela, did not. She cited on the record. We have the wife's name is Maria A., born on the 2nd of August, 1880, in Salerno, Italy. Almost all of that is wrong, but it's still his wife. So then we have the wife, Maria Arcangela Amabile, married Dame Varallo. She never became a U.S. citizen. And in fact, in 1940, when Congress passed the alien registration requirement, she registered as an alien. So she has a 2-page AR2, as it's called, on file. These recently moved to the National Archives, and she never became a U.S. citizen. So sometimes it's actually good if you're trying to find records of people. Sometimes it's good when a husband naturalized post 22, because if he naturalized in 21, then chances are there's going to be the petition and basically nothing else. There'd be a couple other things here or there that are not really worth covering, but essentially you'd have the petition and maybe some other records that summarize the petition. And it'd apply to the wife as well. The wife probably would not have a derivative C file. She legally could if she fit the qualifications, but she likely would not have one. Whereas if a husband naturalizes in 23 or 24 or anytime after 22, the wife's citizenship has not been covered. So there's going to be other records. Either she has her own petition with her own biographical information, or she's an alien. And if she knew she were an alien, which is always an if, and if she complied with the laws, which is also an if, she would have alien registration records. 5.5 million aliens registered in 1940 with these 2-page forms. So, as a case study here, I started doing genealogy when I was 13 years old. And when I was 19, I finally figured out where this woman was born. And it's because I decided to just work out from her husband's town of birth in concentric circles. And I went town by town from where he was from until I found her birth record. And I found it in Tejano. I did not know about AR2s because I was a child. But had I known to get her AR2, I'd have gotten that. It would have cost me $30 back then. I got it in a couple of months. And lo and behold, it says that she was born in Tejano. So these are very useful records. Now, AR2s are honestly a little boring for most people. It has their date of birth, their place of birth, their arrival date, and information to the best of their recollection. If you don't know that, that's very, very useful. If you do know that already, the AR2 is going to probably not have much. I should clarify. The picture is my own picture. That was not with the file. That's from my Aunt Ginger. That is not with that. Many INS records do have pictures, not AR2s. So it asks about other kinds of service, if you've been in the military, if you have any criminal offenses. Women don't generally answer yes to those questions. I'm sure eventually I'll find one where they do, and it'll be very cool. But for the most part, women are going to have a very bland second page. Sometimes for question 10, they'll be in the ladies' auxiliary of some kind of social organization, or they'll be in the Steamsters Union, which is always cool. But that's really all you're going to get on page 2 for women for the most part. I'd love you to prove me wrong and find really cool stuff, but it's just not as common. Now here we have an example where there actually is a photograph of a woman. So A files are the successor to the AR2s. If you are still an alien in 1944, you could potentially have an A file. Now I'm giving a webinar on Thursday, I think at 4:30-ish, something like that. Today's Thursday. Friday, tomorrow afternoon, I'm giving a webinar all about A files. So we're going to discuss this tomorrow. Please come. But in a 30-second version, it is a file about aliens. And if your ancestor was an alien in 1944 or later, they could have one. And they're very cool. And in this case, there is a photograph. So this picture of my Aunt Conchetta is actually from her A file. I'd never seen a picture of her before that, but it was in the A file. Okay, moving on. We have some fun charts. I want to credit Marion Smith. I believe I credit her in my syllabus as well. But Marion Smith is the former historian for USCIS, which I should have specified is United States Citizenship and Immigration Services. It is the agency that is now what many people knew of as INS before the Homeland Security Act changed everything. The Immigration and Naturalization Service was the name of this agency for much of the late 20th century. That was the creation of the Bureau of Immigration and Naturalization, which became part of the DOJ and the Department of Labor. And there was a whole administrative history that doesn't entirely matter for now. But understand that USCIS is the current agency. They have a lot of records. We'll talk about it more tomorrow. But here we have a nice little chart that essentially summarizes everything made by Marion Smith, a brilliant historian who knows more about these records than probably anyone on earth. And it really just goes into everything I said. And this is in the handout, but just be aware that this exists, and it's a nice little cheat sheet to show you what I'm saying exists for what years. Okay, it is 10:06. We got 25 more minutes, including questions. So we're going to move on to children, which is luckily less complicated. So with children didn't naturalize, basically. But there were expedited naturalization procedures given to those who arrived as minors. So at around the turn of the century, the late 1800s, early 1900s, you'll often find cases of immigrants that arrived as a 16-year-old on their own who needed to become US citizens because they were alien children, which is not great for anybody. And they were given these expedited paths to naturalize, again, waiving the declaration requirement, things like that. And here we have an example of somebody who naturalized in New York. And attached to the petition is actually a little letter from the special deputy collector from the Customs Service about how this guy, yes, did arrive as a minor. And there's lots of records like this, and they're all in the court records interspersed with the rest of them. Here we have Andrea Colucci, who again arrived as a minor and was given expedited naturalization in Queens. And it even says up top, alien minor. And he was given citizenship in 1900. Now, this was all fine and dandy until the fraud, because when you have expedited naturalization, it means there's less scrutiny and fewer requirements, which means it's easier to cheat. So there were a lot of immigrants who were not minors who managed to get papers that portrayed them as minors. And there were all these different fraud rings of people who were naturalizing under this expedited path who should not have been eligible. And eventually the feds cracked down and stopped this whole process entirely. But you will see records that indicate this expedited naturalization, and that's why it exists. But now, for the most part, when we're looking at children, really what's relevant is derivation of citizenship, much like women. So when wives derive from their husbands, if there are minor alien children, they would derive as well. So again, let's look at some laws. So in 1802, it was decreed that children born abroad to U.S. citizen fathers are U.S. citizens. And that's actually more about acquisition, which we're going to cover in a bit. But it's the first law that existed historically. So I have it in this section. So if you are a U.S. citizen and you go to France or England or India to do work or on vacation or for whatever reason, if your child is born abroad, because you are a U.S. citizen, your child is also one. It does not matter that they were or weren't born on U.S. soil. And again, that law in 1855 clarified that women and children derive from their U.S. citizen husband. Now, in 1906, we have the laws again that are modernizing and standardizing everything. So we have these bigger, more robust forms that require the names of the children to appear on the petition. Before that, the children's names would virtually never be listed. It did not mean that the children didn't derive, because the wife's name wasn't listed either. It was just implied. So if you were to try to create a proof argument of this derivation, you'd have to say, well, here's the marriage record, here's the naturalization record, here's all the stuff. As of 1906, it's all on one form. Now, of course, if we're trying to be good genealogists, we want to prove the marriage actually happened and they were actually the children in the first place, because it's kind of self-reported. But barring that, the 1906 and later records are much more thorough. And again, in 1922, when the Cable Act happened, children of an alien woman no longer derived U.S. citizenship from their mother upon her marriage to a U.S. citizen husband. So you could actually derive from a step-parent up until that point. Because if your mother was an alien and you were an alien, and your mother married a U.S. citizen, as we've discussed, she'd become a U.S. citizen. But the laws generally provided that the children of citizens would become citizens, so you, as the child, would also have become a citizen. In 22, all that goes away. So there are a bunch of different laws about how derivative citizenship happens, and I have links to this in the handouts. I'm not going to read these charts to you, but essentially, different laws at different times had different rules. So sometimes both parents had to naturalize, sometimes one parent had to naturalize, sometimes if the parent was divorced, one parent had to naturalize. If you were adopted, it was this. If you were born out of wedlock, it was that. If you were born abroad, it was this. You get the idea. Read the chart. Don't listen to me. I do not even know this stuff offhand. So when I have a client case where there's a child who's the parent is naturalizing in 1931 and the kid is 7 years old and he's living abroad still, what happened? I don't know. I go to my chart. And then I read the different chart and we just essentially figure out which law applies as the time of the naturalization. And then we can read across left to right to figure out which situation applies. Generally, people we're researching are the children of married couples. So we're going to look at the first part, but there are many other situations that apply often enough, and those are covered as we move to the right. So here we have an example of a court naturalization that I got from the National Archives of Dominic Durante, who's naturalizing in 1894. The record is boring, as are most court naturalizations. But I was trying to figure out if this guy was the father of my research subject, Ralph Durante, because I was trying to figure out if Ralph had derived citizenship or not. I was very lucky because in 1919, the courts were trying to figure out the exact same thing because Ralph wanted to know if he was a U.S. citizen. And there was a letter from the Naturalization Service attached to this that covered exactly what I was trying to figure out. And it referenced how Ralph Durante was writing to figure out his situation. And lo and behold, this was in fact the father. He had derived citizenship and was covered in here, but only because Ralph happened to write and ask. This is rare. I would not have expected this. It made my work much easier. It was a good day. I looked really cool to the client, but usually you have to just infer this. And it's often difficult because these earlier records are very boring. We have to figure out, well, how many Dominic Durantes live in this area? Could it be other people of the same name? And using all those research strategies that we do all the time with genealogy research. But here it was laid out for me very clearly. Now, as I said, in 1906, the requirement to add the children's name begins. So this is easier because we have the records. I mentioned my fifth cousin Irene. This is the husband. So both Irene and Alfred Zaitchek's records both list out the spouse's information, their information, the children's information. So they had a son, Herbert, who was born in 1935 in Vienna and resides in New York City. He was going to derive citizenship because both the parents naturalized. And if we want to figure out exactly what law applies, we'd have to figure out what laws on the books in the 1940s and what has to happen. Generally speaking, if both parents naturalize while the kid's a minor, he'll derive, which he did, and now he's a citizen. Now, here we have my grandfather Solomon. Solomon naturalizes in 1923, just after the Cable Act. So his wife, Anna, never became a U.S. citizen. And I myself did not realize this until about a year and a half ago, because I found this naturalization record when I was 14 years old. I didn't know about the Cable Act. I, like many immigrants back then, just assumed that the wife became a citizen too. So I believe that Anna, my great-great-grandmother, had always been a derived citizen, but she wasn't because he naturalized too late. So she actually has an AR2. But anyway, this is about her daughter. Her daughter, Mary, was born in London in 1910. She was 13 when Solomon naturalized, and she derived citizenship in 1923. But she wanted proof of citizenship. So I actually found this letter at my grandmother's house. It's a letter from the Immigration Service, and it was about my great-grandmother, Mary, trying to get proof of citizenship so she could register to vote. And basically, they were able to determine that, yes, she did derive citizenship because Solomon naturalized when she was a kid, blah, 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 blah. But Mary doesn't actually have any records of having derived. I had hoped that the fact that this letter existed might have meant that there had been one of those derivative C files generated. There wasn't. So USCIS has nothing on file for my great-grandma Mary. She was an immigrant. She was born in England. But the only record of her naturalization is her father's naturalization. And that was even confirmed in the 60s by INS in that letter that I found in my grandmother's house. Now, some people did register the derivative citizenship, and these are in those derivative C files. So here we have Ray Kestenbaum, who was born in Canada. Her parents naturalized, their father naturalized when she was a kid, so she derived citizenship. Years later, She wanted proof of citizenship that was more thorough. So she filled out the proper paperwork, generated a file with INS, and now has a pages-long file documenting that she derived. It is not required to have done this. Immigrants only did it if they wanted to. If for some reason they believe they needed more thorough documented proof of their citizenship. But it's always great when that happens. So just to run through some of these laws. As of March 2nd, 29, much like with women, children who derive U.S. citizenship through a parent's naturalization could apply for that certificate of derivative citizenship, which is what I was just talking about. Starting in 34, if you were a child of a U.S. citizen who was born abroad, you only derived if both parents were U.S. citizens, or if one citizen parent and the child established U.S. residence as a minor, which again is a bit convoluted to read. But essentially, it sets limits on how children born abroad would become citizens. So it wasn't necessarily always and forever. There were some rules. So there were residency requirements. There were requirements about both parents, and these just laws happened throughout the years. But this is one of the main ones. There was a big court case in 1939 that U.S.-born children, who were expatriated by a parent's foreign naturalization, could elect to retain their U.S. citizenship. Expatriation is a really fun topic. I may make a talk on that one day. I don't have it yet. But expatriation records are very interesting because people who became U.S. citizens could lose it by moving abroad and doing some things. And this caused a whole ripple effect for their children because the children who didn't do those things sometimes lost their citizenship too. And we're not going to cover it today, but be aware that expatriation exists and is a very wild field of study. Okay, so anyway, starting in 1940, there was a new law. U.S. citizen parents could file a petition for naturalization on behalf of a minor child. So children could still derive citizenship if their parents fulfilled the conditions as per those charts I showed you, but you could also naturalize your child on their behalf. And starting in 44, children who acquired U.S. citizenship by birth abroad to U.S. parents could also apply for one of those derivative certificates. This actually created a new series. They were called the AA C-files, acquired abroad. And again, it's the same kind of thing. It's a C-file for people who became citizens, but these are ones who became citizens from the moment of their birth by virtue of being born to U.S. citizen. Again, we could discuss these C-files for an entire hour. We have to go through them very, very quickly today because there's a lot of content. So here we have records from Ray Freeman's naturalization file, derivative citizenship file again. And this is indicative of a typical file. We have records of her birth from Canada. They couldn't find us, so we have her their baby naming record from the synagogue, all kinds of stuff. We have the actual certificate of citizenship and the oath of allegiance. And again, these are just some pages. Now, interestingly enough, we still have to understand the laws to make proper conclusions. Here we have Marie Sarnelli. She immigrated to the U.S. in 1956. In her A file, we have her visa, her birth certificate, and not much else. She came here as a child and basically never interacted with the government ever again. So on behalf of her child, I requested records from USCIS confirming that Marie Sarnelli never became a U.S. citizen, which we needed for various legal purposes. And I was granted the certificate. They said that they looked up her A file, they saw there was no naturalization record in there, and they said, yes, Maria Adele Sarnelli is an alien. So it's not true. She derived from her parents. If you go to the charts, read the rules, if both the parents naturalized before a certain age, she would derive citizenship. Sure enough, her father and her mother both became citizens in the 1960s. At the date of these second naturalization, Marie derived citizenship. But Marie never opted to have this recognized by the government. She never cared. Honestly, I think she never even knew she was a citizen because there's a family story that she got a stolen passport because she wasn't a citizen and had to travel abroad, except she was a citizen and could have just gotten a proper passport. Fun stuff. So anyway, one more example. Here we have anyone from the New York area might know the Jim Lucille Roberts. This is Lucille. Lucille was a Jewish refugee who came in 1951. You have her A file here. And she, in the 50s, filed to become a citizen, only to discover she already was one because her parents had naturalized. Much like Marie Sarnelli, her parents had naturalized while she was a minor. She became a U.S. citizen automatically by operation of law. She didn't realize it. But unlike Marie, she began the process of naturalizing, and the courts and everything kind of put it all together, and they realized this is a waste of time. You're already a citizen. And she stopped naturalizing and instead was given a certificate of citizenship. Okay, one more fun example. We have Giuseppe Storti. He immigrates in 1920, 1915-ish, marries someone bigamously, Dina. This is his second wife, but he's still married to the first wife. When he naturalizes in the 20s, he only cites the second wife. So he has the second wife cited with the new child from the second marriage born. His first marriage's children are still in Italy. They eventually immigrate, except they should be citizens because they were born to someone in 1905 who eventually became a U.S. citizen while they were a minor. Under the laws at that time, they derived. So long story short, when the son from the first marriage tried to eventually become a citizen, it created all this chaos because the naturalization petition did not list him as a child. And the husband, the father, got caught as a bigamist. And the derivative citizenship file was 100 pages long. And there are all these interview transcripts where they're saying to the father, what did you do? Were you still married? Are you still this? Are you still that? We don't have time to go through it all. But essentially, there was a lot of discussion. And of course, he said he made a mistake and omitted the name of his first wife. He was in deportation proceedings for a while over this. It was a whole what to do. Eventually, it was settled and everybody got their citizenship recognized. But there were lots of records, and they're all in the USCIS files. And sure enough, this is the son's certificate of citizenship. He was recognized as a U.S. citizen from having derived from his father, and eventually all the paperwork got cleared up. Okay, so we're almost done here, but the last thing to discuss is acquisition. So this is mostly about derivation, where you are born an alien and your parent naturalizes. But I've highlighted a little bit already about acquisition, where you were born as a U.S. citizen abroad. So we have similar kinds of charts that dictate how and when one acquires citizenship. And these are often going to lead to even more cool and exciting records. So here we have a guy who immigrates in 1956 on a visa because he believes he is an alien. It turns out he's not. He was actually a citizen. So we got to blow this a little bit. But basically, his father had come to the U.S. years earlier and had naturalized. And the father then moved back to Greece and expatriated. But because the son was born while the father was still a U.S. citizen, and before he expatriated, the son was born a U.S. citizen and did not lose it because native-born Americans could not lose their citizenship, even if the father did. And this is all covered in the son's A file, which again, come tomorrow, we'll learn about this in more depth. But there were copies of the father's naturalization records, copies of the father's passport records, all of this discussion. And eventually they determined that the son was in fact a U.S. citizen and did not need a visa and did not need to naturalize because he already had U.S. citizenship. And there we have his certificate of citizenship. And again, note the AA number on the top because he acquired citizenship abroad at birth. Okay, so that is the end of my talk. I apologize for being so quick, but I do have to cover one last thing. Sorry, being so quick. I apologize for covering things so quickly, but there's a lot of material. And I have one last thing to say. The National Archives is potentially at risk right now. All the records that I looked at today are stored by the National Archives, and their budget is potentially going to face major cuts in the coming years. And it is imperative that genealogists reach out to the legislators and explain how important the National Archives is. A coalition of genealogists have developed a website, fundnara.com. We have a QR code here to discuss the importance of the National Archives. But in the context of this talk, what we've looked at today, naturalization petitions, the repatriation records, the AR2s, some A files, older passports, they are all owned by the National Archives. The National Archives spends hundreds of millions of dollars a year to store these records, to protect these records, and to digitize these records. Without the National Archives doing that, the records will deteriorate, they will be inaccessible, things that are not online may never go online. Many of the records we looked at today are not officially owned by the National Archives. They're still with USCIS, but they're stored at federal record centers. These are centers that the National Archives owns and operates that act as warehouses for the agencies. Things like the P files, the paper C files, most A files, later passports. These records one day will go to NARA and become much more accessible than they are right now, but only if the National Archives has the funding to accession millions of cubic feet of records. And I apologize for the soapbox, but I just wanted to say that the National Archives are vitally important for genealogists. They're the most important entity. And without them being properly funded, we will not be able to do the research we did today. So I ask everyone to please advocate for the National Archives support and to go to the link fundnara.com. Okay, we have a few minutes for questions. I apologize for the delay. People can always email me with questions that we can't cover. So I'm ready.
Questions that are from the online viewers. Montserrat Sanchez 3 asks, where can I access all of these documents? I assume.
Yes. So I would love to go into specifics of how to find every single record today, and that would be 4 more hours. But basically, the National Archives and USCIS are the answers. So the USCIS genealogy program houses C files, A files for most of them, other kinds of records, and you essentially pay them a fee and they will send you a record. The USCIS genealogy program, again, I have whole talks on it, so just go on the website for now. It'll explain briefly. Everything else is at the National Archives. Some records have been digitized, some have not. And of course, some naturalizations aren't at the National Archives if they're local level records. Again, it would be a whole hour-long talk of discussing how to find these records. It just can't be covered. But essentially, the National Archives is the answer at least half the time.
All right. And Tina L asks, how can I get help with these records, researching them and understanding them?
Yeah, so I find that there is not a lot of genealogical knowledge about these 20th century records. I offer a institute course with Rich Venezia and Marion Smith every now and then, where we talk about this for a whole week, which is much more valuable. It is not currently being offered. We've not done it at an institute the next year or so, at least for now. I give webinars as often as I'm invited to give webinars. So I'm happy to come talk about this to any group that wants to bring me in. But unfortunately, other than hiring a professional genealogist or reading some of the books that are out there or just kind of diving in head first, there's not a lot of great sources. I hope the handout can guide you somewhat, but there's just not a lot out there.
All right, thank you very much. Do we have any in-person questions?
Yes. You mentioned that the National Archives is under federal funding. Is it also true with the USCIS that's going to be a problem? Or since it's fee-based, is it?
So the question, I'm not sure if you could hear it in the audience. The question was, is it possible that the USCIS records will also be under threat from funding cuts? So you are correct that USCIS is largely fee funded. They really don't get money from Congress. So I don't anticipate Congress being an issue with USCIS records. But for years now, USCIS has tried to raise the fees drastically. We've had to do big advocacy campaigns to fight them. They were trying to raise the fees to about $400 for a document, and they eventually relented. Now it's only $30. So the records are under threat, and USCIS is not a proper archive. The bigger problem is that they don't even know how to properly find their records. Half the time you make a request, you get the wrong thing, you get half the file. The records need to move to NARA where proper archivists can store them, but without NARA having the resources to process the records, it can't happen. Okay, we are at 10:30. Anybody who has questions, feel free to email me. I'll be here in person all week, and I will see you hopefully tomorrow with A files. Thank you.